He says res ipsa loquitur. That's Latin for the thing speaks for itself. And this, no, this is a legal proof. The thing does not speak for itself. No one knows what happened with Margaret M. Sweeney in case number 1029 in document 6. We would have to go there and read it, but you're presenting it to us. So no, you show us.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
In the United States District Court for the District of Columbia, this matter is before the court on its initial review of plaintiff Edward Thomas Kennedy's pro se complaint, which is accompanied by an application to proceed in forma pauperis, which means as a poor person, which is not a criticism, it's a legal category. The court will grant the application to proceed in forma pauperis, but dismiss the complaint. Plaintiff alleges that judges of the United States Court of Federal Claims, I don't know if you remember the last time we heard from Edward Thomas Kennedy, he was suing in the United States Court of Federal Claims. I guess he didn't get his way. The U.S. Court of Federal Claims allegedly violated his right to due process when each dismissed a case plaintiff had filed in that court. Remember, each judge. As compensation for the monetary losses and emotional distress plaintiff has suffered as a result, he demands compensatory damages totaling $6,015,000 plus punitive damages. Any actions the defendant judges have taken were in their judicial capacity. Plaintiffs' claims against them cannot survive because the defendants enjoy absolute immunity from suit. See Morales v. Waco, a 1991 case, finding that judicial immunity is an immunity from suit, not just from ultimate assessment of damages. See Stump v. Sparkman, a 1978 Supreme Court case, concluding that a state judge, was immune from damages liability even if his decision was in error. See Pearson versus Ray, a 1967 Supreme Court case. Few doctrines were more solidly established at common law than the immunity of judges from liability for damages for acts committed within their judicial jurisdiction, as this court recognized when it adopted the doctrine in Bradley v. Fisher. See also Forrester v. White, discussing purposes served by judicial immunity from liability in damages. The court grants plaintiff's application to proceed in forma pauperis, but dismisses the complaint and this civil action, an order issued separately. United States District Judge Christopher Cooper for the District of Columbia Court. So, no, we're not done there, because I figured how fun would it be if we just stopped with his smackdown, his 2-page smackdown. So let's look at what he actually filed, and then we'll try to lawyer it. You know, like gets lawyered video, like let's look at sovereign citizen gets lawyered. What do you think? That sounds fun, right? And so let's look at the Edward Thomas Kennedy versus Hodges, Brugink, Sweeney, Wolski, and the United States Court of Federal Claims. And this is Edward Thomas Kennedy speaking. This is his complaint. Take judicial cognizance and notice, which, I mean, it's flourishing language. Lawyers do this too. You don't need to say anything like that, but sure. In accordance with the provisions of 28 U.S. Code 636, the plaintiff declines to have a United States magistrate judge conduct any proceedings in this case, and the plaintiff hereby requests that the case be assigned to a United States district judge. And that's something that you can do. You can decline in, I don't know if it's everywhere, but many courts allow you to decline the use of a magistrate judge. A magistrate judge is usually a judge that helps organize cases for a district judge, and they usually make recommendations to the district judge. So Edward Thomas Kennedy does not want a magistrate judge on his case. The law of the case, Exhibit 1, is hereby incorporated by reference as though fully stated herein. He's starting to copy the language that like lawyers use in their briefs. And then he just cites to 28 USC 1361 and 18 USC 101, which I guess we can look up. I mean, how much time do we have? is an action to compel an officer of the United States to perform his duty. It says the district court shall have original jurisdiction of any action in the nature of mandamus to compel an officer or employee of the United States or any agency thereof to perform a duty owed to the plaintiff. Well, I mean, Edward Thomas Kennedy is not wrong that that law exists, but see for yourself then in here whether a judicial officer actually owes him a duty. And then what was the other one? This is statements or entries, except as otherwise provided, whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government knowingly or willfully falsifies, conceals, materially false, fictitious, fraudulent statements, makes false writings, etc. This is a criminal code, and it does not apply to a party to a judicial proceeding or that party's counsel or statements, representations, or writings or documents submitted. So this is the don't lie to the government law, and it doesn't mean you can't lie to a court. There are other laws why you can't lie to a court, but this particular law is not the law that makes it illegal to lie to a court. This is the one that makes it illegal to lie to the government, to the executive branch, to the legislative branch, or to the judicial branch of the government. So he says the defendant, United States Court of Federal Claims, is a court of record and not an Article 3 court, and is not an administrative court. Court of record is defined in detail in Exhibit 1 attached to this complaint, which we'll get to that in a moment. Preliminary statement. Edward Thomas Kennedy, he is one of the people of Pennsylvania, and in this court of record hereby brings this action against the United States Court of Federal Claims and a bunch of judges, seeking redress for the extraordinary misconduct of 4 judges employed at the defendant, who conspired to and ultimately did use improper, unlawful, and unconstitutional means to falsely and unlawfully deny the plaintiff justice and relief arising out of incidents that occurred in the District of Columbia. The actions and conduct of the above identified defendant judges were the result of unlawful and deficient policies, practices, customs, deliberate indifferences on the part of the defendant federal claims court, including the failure to take disciplinary and remedial action against the above identified defendant judges, and despite documented well-known instances and or records of judicial misconduct and abuses of authority or power, and the obvious direct conflicts of interest present in and surrounding the within plaintiff's claims in federal claims court on the part of all defendants. Does anyone know what the claims are yet? I know we're only on paragraph 4 of page 3, but still. This action is brought pursuant to 42 U.S.C. 1983. That's the civil rights statute denying someone a right under color of law. Jurisdiction is founded upon 28 U.S.C. 1331, which is federal question jurisdiction. And I don't remember what 1343 is. Let's test me. 28 U.S.C. 1331 is federal question. Ha 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 ha! I'm a real lawyer. I went to real law school. The district courts have original jurisdiction for civil rights matters. That's what the other one was. The plaintiff invokes supplemental jurisdiction. Supplemental jurisdiction allows you to assert state law claims in federal court as long as you have a federal claim, a primary federal claim. And venue is proper in D.C. District according to him, as acts or failure to act here occurred in the District of Columbia. All right, so he talks about jurisdiction, monetary and compensatory damages, and attorney's fees according to, I believe it's also part of the civil rights law. The plaintiff is one of the people of Pennsylvania and a resident of the Commonwealth. The defendant, United States Court of Federal Claims, is a corporation in D.C. Brugink, Sweeney, Wolski, and Hodges are U.S. citizens and employed by the Court of Federal Claims, and there's more than $250,000 at stake. Well, of course, because he's asking for what, $6 million? Here we go. Facts. Individual defendants herein are not Article 3 judges. What do you think he means by that? He means Article 3 of the United States Constitution. Let me write it down here. I'll show you what he means. If we go to U.S. Constitution, Article 3, it starts, the judicial power of the United States shall be vested in a Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So that means that the Congress has established, it doesn't establish the Supreme Court, but it does establish the circuit appellate, 13 appellate court circuits, and it does establish the district courts, and it does establish the bankruptcy courts, etc. Those are the Article 3 courts. State courts are not Article 3 courts because they are not, wait for it, the United States. They are the states that make up the United States, and they have their own sovereignty, and so they have their own court systems that are not called Article 3 courts. So that's what he's referring to when he talks about Article 3 courts. Just so, because he's going to get to this a little bit later as well, the judicial power shall extend to all cases in law and equity arising under this Constitution. We used to have courts of equity and courts of law. The courts of equity would handle things that had to be ordered done, and the courts of law would handle things that had to be ordered paid. So courts of equity were basically injunctions, and courts of law were monetary damages. No, I don't completely understand it myself either. I'm not that level of legal historian, but sometime in the early 1900s, I believe, the two were merged, and we now have courts. And there is no attorney at equity, attorney at law, or whatever. All that stuff is fluff now. It's just law. It's just, everything is just law. And so we might say that there is an equitable remedy. It's the same thing as saying that there's an injunction or a relief under the old law of equity or the common law of equity or something like that. And even I am probably slightly misstating this because, like I said, this is complicated and I don't quite understand it. Now, if it's confusing to me, it's very possible it's confusing to Edward Thomas Kennedy. And I don't mean that with any arrogance. He's probably smarter than me in many respects. I just don't think that if he's having this much trouble with the law, that he's going to just suddenly understand law and equity better than people who are trying to understand it. And let's see what Section 3 is. Treason. Okay, so we're not even worried about that. In a court of record, a judge has no discretion. Absolutely not true. Those two things are not connected. Being in a court of record has nothing to do with whether the judge has discretion. The judge, remember your checks and balances, the judge does not make the laws. The judge does not enforce the laws. The judge interprets the laws and applies the laws to an individual case or controversy. At least the case or controversy requirement is how jurisdiction is written in the federal court system. So when he says a judge has no discretion, that's a misstatement completely. Judges don't have unlimited discretion. They have discretion that is limited by the scope of the case that they're reviewing. If it's the first time, if they're a court of original jurisdiction and they're reviewing it for the first time, they're going to be able to review anything that is within the laws of evidence and procedure and the substantive law of the case. So if something is relevant, they'll be able to let it into the record. If something is irrelevant and there's an objection made, then they can sustain an objection and then maybe even sustain a motion to strike and remove that evidence, that irrelevant evidence from the record. So the judge has the discretion to do certain things within that. The judge has the discretion to evaluate credibility of witnesses and allow and make decisions about the relevance of facts and testimony and all that. So that's discretion right there. Judicial immunity is a myth when a judge exceeds the court's jurisdiction and injures the plaintiff in loss of rights. Well, it's a nothing sentence. Judicial immunity is a myth with no citation, no citation to what source of anything invalidates judicial immunity. What are the circumstances under which absolute judicial immunity? What are the circumstances under which you can breach that? Like we talked about piercing the corporate veil in the previous story. well, breaching judicial immunity is possible, but it's got a really high standard. The judge has to basically act outside of their discretion, and severely enough to be basically considered misconduct. So, yes, that's what he's going to allege here in so many words. Let's look at some more of those words. Injures the plaintiff in loss of rights is just a weird way of saying injures the plaintiff. It's like Department of Redundancy Department. Res ipsa loquitur. In a court of record in the federal claims, defendant Margaret Sweeney trespassed on the case and exceeded the court's jurisdiction because she exceeded the court's jurisdiction and injured the plaintiff in loss of rights. It's a very conclusory sentence, but let's look at this one thing. He says, res ipsa loquitur. That's Latin for the thing speaks for itself. And this, no, this is a legal proof. The thing does not speak for itself. No one knows what happened with Margaret M. Sweeney in case number 1029 in document 6. We would have to go there and read it, but you're presenting it to us. So no, you show us. And then what's this thing with trespass on the case? He does this all the time. What the heck is trespass on the case? I have absolutely no idea what the heck he thinks this means. Let's see what trespass on the case is an old writ, and it's a catch-all tort from English common law. Trespass against the person and trespass against anything else. So there's trespass, which is trespass against the person, and trespass on the case is trespass against a person's something, like their property or maybe their personal effects or something. Yeah, this is not talking about trespass on like someone's lawsuit case. This is talking about a trespass on someone's personal things. Claims could only be litigated in the royal courts, and only if there was violence or force. So this is an ancient common law doctrine that is similar to some kind of negligence or intentional tort. So it's been adapted to today is basically what has happened here. So he's saying the judge, I think he is saying trespassed on the case, and I think he means lawsuit case, but what it really means is that he's accusing them of negligence in their duties. So some kind of negligence or dereliction of duty. And he goes on to restate this, like all these things speak for themselves. Then he says that a judge in a court of record has no discretion and no immunity when the judge exceeds the court's jurisdiction and injures the plaintiff in loss and rights. No, actually, that's not true. When the judge exceeds the court's jurisdiction, you have an appealable issue and you can get the case thrown out or whatever the appropriate thing to do is when the judge exceeds the jurisdiction of the. So what does this mean? This means that if a judge across the country enters an order that Leonard French did something and I can prove that I didn't do it, it still means I have to go and respond, and I can't go and just sue the judge for entering an incorrect order. There might be some kind of claim, but I have to find some grounds for that claim. You cannot automatically sue a sovereign state or federal government without further claim. Like 42 USC is a good one, but it doesn't cover everything. As a direct and proximate result of the actions of all defendants, plaintiff has been caused to suffer damages and injuries. Can any of you tell me what injury he suffered yet? Like what happened? All I can see is that he doesn't like that a judge did something and that it speaks for itself. But that's all we know at this point. We don't actually know anything about what happened.
I remember in undergrad, I had a TA eventually just sit me down at one point and say, like, okay, your essay is not a mystery novel. Don't surprise us at the end with what your conclusion is. Like, start with the conclusion and get right to it.
Road mapping, signposting. Let us know where you're going, what we're going to learn. I'm not that great at it either. Like, you see me struggle with it here, but you see me getting better at it as we practice more and more and more. And so he continues with his sort of non-description of what's going on here. As a direct and proximate result, he suffered emotional stress. That's great. Emotional stress or emotional distress is not an actionable thing. until it reaches a very high level. And he says that he suffered severe anxiety and embarrassment, asks for $6 million plus $15,000 in costs for legal expenses, research expenses, photocopies, postage, and attorney's fees. I would love to meet the attorney that has represented him, although I'm not sure I could actually get anything out of the attorney. I wouldn't want to, like, even if I did get something out of them, then I know that they've committed some kind of confidentiality violation. So he wants punitive damages against the 4 judges and other costs. So he's alleging violations of civil rights. It just concludes that he's suffered violations of civil rights. This might be it. The dismissal of plaintiff's claims against the United States of America was all done without reasonable or justifiable grounds. Does he know what a legal proof is? Like, we could believe this if he was showing us the legal proof. This judge did this. The judge was supposed to do this. Here's the law. Here's how the law applies to my case, and here's what I want. Like, something like that. The judges knew they lacked authority to dismiss his claims, but they did so intentionally and maliciously. Why would a judge lack the authority to dismiss claims? Judge would have the authority to dismiss claims. I believe the judges even cited the authority to dismiss claims. I believe the judge cited the authority to dismiss the claim. I mean, we're looking at the authority. Like, the judge literally is like, here are the places where you're not allowed, where it says you're not allowed to sue a judge. So Edward Thomas Kennedy, as much as we didn't want to go read his res ipsa loquitur cases, he should go read these cases that are cited here in the judge's opinion, because they will say that you can't sue a judge under these circumstances. As a result of the concerted efforts of the defendants, resulting in fake justice, the defendants denied the plaintiff justice intentionally and or with deliberate indifference and callous disregard to the plaintiff's rights as guaranteed by the 4th and 14th Amendment of the Constitution. No, I think that's the Equal Protection Clause that he's talking about. The Due Process and Equal Protection Clauses, yeah, they guarantee you the due process of law, which is the notice of any charges against you and a meaningful opportunity to respond. Meaningful, meaning that it's not just a kangaroo court, it's not just a sham court, it's not just a proceeding only where they already have determined the outcome, but rather they have to sincerely weigh your testimony and evidence against others' testimony and evidence and the law, and then give you a somewhat reasoned opinion. The standards are really low for the reasoned opinions. The fact that we're getting reasoned opinions is because of appellate courts, not because the law requires reasoned opinions. Judges can just simply affirm and deny things in many cases. At least that's been my experience. The very meaning of sovereignty is that the decree of the sovereign makes law. We, the people, do not yield our sovereignty to those who serve us. The plaintiff is one of those people. The defendants are to serve the people, and because they failed to serve the plaintiff in his claims against the United States of America, the defendants knowingly and intentionally violated their oaths of office to obey the law and tell the truth. The plaintiff is entitled to punitive damages due to the intentional, malicious, wanton, and willful misconduct of the defendants as a result of the proximate result. As a result of the proximate result? As a result of the proximate result of the intentional, malicious, wanton, and willful actions of the defendants, the plaintiff suffered damages as aforesaid, which are incorporated by reference as if fully set forth herein. This is just nonsense language. This doesn't mean anything. There is nothing here. I still don't know what they did aside from they denied my claims. They denied my claims doesn't tell me anything about the denial of the claims. He wants me to go and do all the research myself, but he also wants me to agree with him. So is he really helping me agree with him if I have to go figure it out for myself? No, I already... Can I say it? I'm sorry, I don't mean to use such strong language, but I already hate him if I'm the judge or the judge's clerk and my duty is to go figure out what he's talking about and I have to go back and research all 4 or 5 of these cases, and he hasn't told us anything about the cases or what his claim is or what it stems from. He hasn't given us any reason to continue reading other than it's such a car wreck that you just kind of have to just crane your neck as you drive by, and you're like, oh my God, it's so bad. It looks so horrible. There's so many body parts on the ground. He's not giving us anything other than that to compel us to stand by his side in the legal sense and argue or affirm his claims. He wants compensatory damages, as he said, 6,015,000, which is a weird number. He continues with 42 USC 1983 violations, saying that they had a responsibility to control. The Federal Court of Claims, the Court of Federal Claims, had the responsibility, duty, authority, and ability to control the actions of their judges and took no steps to prevent them from denying his claims, whatever those claims are. And they tolerated, allowed, encouraged all of these violations, and he asks for 6,015,000. Let's go over for a second what exactly is the Court of Federal Claims, because it is not what he thinks it is. The Court of Federal Claims is a United States court that hears monetary claims against the U.S. government. It's for claims against the government. If the government, let's say the government institutes a regulation requiring you to install a rooftop box on your roof of your house. Yeah, there's a new cable TV standard or a new Wi-Fi internet standard, and the government is going to roll out this rooftop box, and everybody has to put a rooftop box on top of their house. So if you are an owner of any kind, not a renter, but an owner of the building, and you have tenants or residents, you have to have a rooftop box. Well, that would qualify as a taking under United States Constitution Amendment 5. So let's say that the United States did not pay anybody and just started shipping rooftop boxes, and people started putting them on their roofs, and the government started fining people who didn't put them on their roofs, etc. Well, this would qualify as a taking, and you have not been compensated by the government, so you may have a claim. Well, and I'm not 100%, this is not legal advice, you might file your monetary claim for a taking by the federal government in the United States Court of Federal Claims, because it is a monetary claim against the U.S. government. Now, why do I hesitate? Because jurisdiction is complicated, and we would want to look up about 6 more steps to make sure that we would not cite Wikipedia as a source for jurisdiction in the U.S. Court of Federal Claims. However, it's probably a little bit easier than going back here and going up to the U.S. Court of Federal Claims and figuring out jurisdiction using this website. So we would use this website plus the law if we were really doing it for real. Instead, we're going to use Wikipedia to figure out what it is. So if you have a monetary claim against the government, sure. Now, what monetary claim, though, does Edward Thomas Kennedy have? Well, I'm assuming this is like an onion. He's adding layers. So he had a claim against somebody somewhere, and because the judge didn't grant it, he's now complained about the judge to 16 different courts. I'm exaggerating. I don't know how many it is. But he's complained to various judges in various courts, and then when those courts don't do what he wants, he complains to other courts about those judges. So I don't even know what layer of the onion we're in right now. We could be on like the 6th layer of the onion at this point, and he doesn't even know. I mean, maybe on some level he thinks he knows, but I don't think any of us are going to be able to discern who he's actually trying to sue based on what he's presented here. So I'm going to keep going because we have another Edward Thomas Kennedy document to get through. Because remember, he has included Exhibit 1, the law of the case. And that's what I really want to get to lawyer for you here today. This is his law of the case, Exhibit 1. Exhibit 1. Law of the case. Another 9 pages of what he thinks is law, and he's even like put it in 2 columns, and there's citations and everything. So let's see if any of this makes sense. Quote, the very meaning of sovereignty is that the decree of the sovereign makes law. Okay. That's actually true. The law is decreed by the sovereign as follows. Okay, wait, now he's instantly declaring himself to be either the sovereign or source of law, or at least he's organizing the source of law here. So already we're in some questionable territory here. Under the Constitution of the United States, all U.S. courts are courts of record. What? Let's see what his notice also in the Third Circuit, Delaware, Title 10. Okay. I mean, I don't have any reason to think that they're not courts of record. It's just like everything he says, I question. So then he says a court of record, to be a court of record, you must have 4 characteristics and maybe a 5th. 1, a judicial tribunal having attributes and exercising functions independently of the person of the magistrate. Okay, so a judge. So it has a judge. And then he cites 2, Missouri and New York law and Black's Law Dictionary. And then he cites, so again, this is in federal court, he's citing to state law. So maybe he doesn't understand that there's 2 different things going on there. Federal law is not state law. So 2, you must have a proceeding according to the course of common law. That is not true, but he cites to Missouri law, he cites to New York law, and he cites to Black's Law Dictionary. Proceedings will be according to the law of the sovereign you're in. So federal is going to be the Federal Rules of Procedure. Pennsylvania, for example, is the Pennsylvania Rules of Criminal or Civil Procedure. Sure, there's common law, but I don't know that too many states observe common law procedure anymore. I think the procedures have all been codified, and we now have procedure according to code, and you might be able to still bring a claim, a common law claim. But here we're talking about courts of record, so let's hang on. Its acts and judicial proceedings are enrolled or recorded for a perpetual memory and testimony. Not true. He cites here to Florida law, Georgia. Here we go. Georgia code to Louisiana code to Ohio code. Has power to fine or imprison for contempt. Pretty much all courts inherently have the power to fine or imprison for contempt. So there are. Oh, by the way, back to the other thing. There are some courts that are not courts of record. For example, the magisterial courts in Pennsylvania are not courts of record. They're still courts. They don't count in the usual sense, though, because they're not courts of record. You can easily appeal to a court of record. They generally possess a seal. I understand what purpose a seal serves. It's like the signature of the court. So yeah, there's usually some kind of officiality to the court, but I don't know that it's a requirement that if a court doesn't have a seal, then it suddenly has no power. I think that's how that works. And for that, he cites to California law, Ohio law, Louisiana law, Black's Law Dictionary. So again, all state courts. In a court of record, a judge has no discretion. That's also not true. We went over that before. Our mission, our mission through the courts, encouraging the government and its employees to obey the law. So we got this from someplace, and in the middle of the text is like, this is our mission. And did he just copy it like word for word, and that's why it's in here? Or does he really think this way? A judge has no discretion. Here's our mission. Like, what? An attorney at law means one who practices common law. No. There's very little common law left these days. Everything's been codified. An attorney in equity is one who practices before an equity court, except law and equity were merged back in the 1900s. Private member association members of the legal profession are attorneys in equity and not attorneys at law. Private member association? I don't even know what the hell that is. Absolute judicial immunity is a myth, and yet the judge was able to cite all these cases where it's not. A judge does not have absolute immunity. Judicial immunity does not apply when a judge is performing a non-judicial act or when he acts in the absence of all jurisdiction. So you're telling me that judicial immunity doesn't apply when there's no judicial part? Duh.
So basically, if a judge goes and commits a crime, he can't be like, oh, no, I got
I'm a
immunity
judge.
because I'm a judge.
Yeah,
Like,
so
that makes sense. Yeah.
I guess because the word absolute was used, that must mean absolute without any of the other qualifiers in the sentence, like judicial. Statutes are expressions of will from the legislature. Well, I mean, in a sense they are, but they're also the law made by the legislature. To maintain confusion, bar members append the word law to it. What? What? Statutes of law? What? For confusion? It's definitely someone's confused. Definitely someone is very confused. Naturally, one is supposed to then believe that statutory law is the same as and equal to common law. It isn't! Exclamation point! There is no legislative foundation for any bar member to practice law. I'm so confused. Without any, he doesn't cite any foundation. Codes are nothing more than a collection of statutes and other rules arranged by subject instead of being arranged by date. Law beats statutes and statutes beat codes. Statutes are codes, you imbecile.
Edward Thomas Kennedy is using confused ray on you right now, Leonard. Don't let it affect you too much.
Statutes and codes shall be in the rules of decision as long as they are not in conflict with the common law. Okay, so how does law get modified? How would the common law have been developed and how would it have been modified? The common law would have developed in courts. So if someone came to the court system with a problem and law had not developed sufficiently to deal with it, yes, courts could slowly over time create decisions that were then recognized and repeated, and it became what we call common law. That back then, I don't know if they called it common law. Nobody walked into court and said, I'm exercising common law. Maybe somebody one time has said that in the history of humanity, but most of the time you would just cite previous case law. Well, where do you cite previous case law to? Like, where is it created by the legislator? It's not. So you're citing previous case law. Well, the legislature, the legislative branch, Parliament in the UK, I believe, and here it's our Congress, the House and the Senate, overrule the courts if they properly create a law that is not just constitutional, but also passes the Senate and the House bicamerally and is signed by the president, or otherwise is overridden if a veto is overridden by a supermajority of the House and the Senate. Then you can pass a law. A properly passed and properly written law overrides the judges, overrides the judicial branch. If the legislature doesn't like Citizens United money in politics, they can rewrite it. They have to try to stay within the Constitution. Otherwise, the Constitution is the vehicle with which a judge can override the legislature, but only on well-reasoned grounds. So the legislature has power over the common law. So he's got this exactly backwards when he says that common law beats statutes. Statutes and codes shall be in the rules of decision as long as they are not in conflict. We read that already. Nisi prius is defined as a court where civil actions are tried by a single judge sitting with a jury as distinguished from an appellate court. No, but he's not far off. Nisi prius is just a court of original jurisdiction. It's an old term of phrase for a court of original jurisdiction. The mere keeping of a record does not qualify any court to be a court of record. I have no idea what the heck he's thinking about with that. Black's Law Dictionary is not really a source of law, but it certainly is cited by enough judges that you could think so. In Pennsylvania and California, all courts are named as courts of record, so why do we care? Does he not update his law of the case for the various jurisdictions he's in, or does he have absolutely no awareness that there are various jurisdictions? We labored first with vices, now with laws. What the heck does this even mean? The word is often affixed as a kind of elliptical expression to the words rule, order, etc. He's still talking about nisi prius court, and he's still talking about agreeing to proceed. That's probably going to come into this, by that he doesn't agree to jurisdictions or something like that. It is a matter of right that one may demand to be tried in a court of record as defined herein. Again, no citation to anything. I'm going to start skipping here because this is, we still have 5 pages to go. And then he starts citing the Confirmatio Cartarum, which is the charter by Edward, the King of England, October 10th, 1297, which reaffirms, it's not the Magna Carta, I believe it's just Magna Carta, which may be pled as common law. That's actually probably true. That sounds very truthy. And although I don't know my history of the Confirmatio Cartarum, I'm guessing that the common law can be pled before a court in England in 1297. That sounds normal. So he just continues, no state may join the United States unless it is a republic. Okay, I don't actually know what the requirements are for a state to join the United States. The definition of sovereignty retains the meaning it had at the time the U.S. Constitution was formed. Who is a tribunal? Answer, the sovereign, the ultimate judge. No, I think it's those Article 3 courts that he just read. I mean, he told us about them before. At the Revolution, sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subject, with none to govern but themselves. Okay, that's very anthemic, but does it mean anything? Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Okay, so that's Miranda v. Arizona. He's not wrong there. Where rights secured by the Constitution are involved, you're not allowed to, eliminate or even sometimes limit those rights. Okay, great. So this is all like 30,000 foot view stuff. Like, light reflects off the sky and the light, only the blue wavelengths make it to your eyes. And so that's why the sky is some gradient of blue in a normal time. Yeah, okay, but did that mean anything other than, okay, you heard a fun fact, and some of these aren't so fun facts. Did you learn anything? Have we learned anything? I haven't learned anything. I haven't learned anything at all from this. I learned that I remembered what the statute was for federal question jurisdiction. Republican government, one in which the powers of sovereignty are vested in the people and are exercised through the people, either directly or through representatives. Great, we know what a Republican form of government is. Excellent, I'm glad he got that one mostly right. The Commonwealth of Pennsylvania is being cited in the DC thing. The Constitution and the laws of the U.S. and the treaties made under the authority of the United States shall be the supreme law of the land. Yeah, that's normal. Yeah, the Constitution is supreme. Yeah, we got that, okay? If 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any territory, commonwealth, possession, or district in the free exercise or enjoyment of the right or privilege secured by the Constitution, or if 2 or more persons go in disguise on the highway or on the premises of another with the intent to prevent or hinder his free exercise, they shall be fined under this title. He's citing a section of the criminal law for kidnapping and aggravated assault, etc. And then he's citing deprivation of rights under color of law. That's 42 USC 1983. Or at least something that's written like it. He's citing it as 18 USC 242. So none of this makes any sense. This is the Chewbacca defense taken to its unfortunate hyperbolic conclusion. If one was to set the Chewbacca defense on a asymptote and just let it keep going, this is what you got. You got Voyager 1. It's going as far. It's still going. It's just we don't even know what it's doing anymore. It's still going. It's the Chewbacca defense taken to a very hyperbolic conclusion. And I hope you were entertained by that. And I hope you were entertained by my absolute befuddlement, my glass case of emotions over here. trying to understand what in the world Edward Thomas Kennedy is getting at, and what I can't even begin to perceive how his brain processes this information and what he thinks is really going on here. Just I am absolutely befuddled. Let me know what you think of my befuddlement in the comments below. So that is our show, everybody. Thank you for joining me. I am Leonard French, your favorite copyright attorney. I'm going to let you go with a short one here. Thank you to our sponsor for the month of October, Joshua Davis from TandaPay. Thank you to our $50 plus supporters, who are Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. And thank you to the $5 plus supporters scrolling on the LED panel behind me and the crawl in front of me. Please support us on patreon.com/ljfrench and sponsors.com/law. Sorry, Brandon, for screwing the order of that up. I am Leonard French, your favorite copyright attorney. I'll see you in the videos that drop. Have a good one. Love you all. Bye.